Welcome everyone for our last panel of the event, panel 6. What practical lessons can be drawn from the situation of Syria? And I will begin by introducing our moderator, Ambassador Beth Van Schaak. And just to say briefly from her bio that she serves currently as Ambassador at Large for Global Criminal Justice at the U.S. Department of State. Prior to this, she was the Leah Kaplan Visiting Professor in Human Rights at Stanford Law School. She has served on numerous faculties, and she, I think, particularly admirably advises a number of human rights and international justice organizations, so spreads her knowledge quite widely, which is much appreciated. I will turn it over to the ambassador, but just a quick program note that she will be, in lieu of her original keynote, delivering some concluding remarks for the conference, which she will just move into as soon as this panel is finished, and that will be probably another 10 or 15 minutes when the panel is finished. So without further ado, thank you very much for all of you for being here, and we look forward to hearing from you. Thank you.
Great. Thanks so much, Jennifer, and thanks so much for the organizers. This has been such a rich and creative conversation. We've covered so many important topics. I really feel like we moved the thinking forward. And so it's been a real joy to be here, and particularly to be here in person and see so many people that we haven't been able to see in many years. So that's been a real wonderful, wonderful convening power of this amazing academy. So the topic of this panel is lessons learned from the Syrian situation. And a very important development was already discussed earlier in the conference, which is many people were disappointed that the Security Council was not able to refer the matter of Syria to the ICC. And yet, as a result, I think it has spurred a lot of forced creativity amongst the international community to come up with other ways to advance the imperative of accountability. And as a result, we've created a whole series of really creative, interesting new institutions, new models, new types of partnerships, public, private, multilateral, very local, and also contributed, I think, to new methodologies for evidence collection, evidence analysis. And so while many might be disappointed that the ICC has not seized this matter, nonetheless, it's created a whole new set of ideas that we can now use and think about adapting for other purposes, including, as we're going to see, in Ukraine. And I think we'll circle around with this conversation to think about what lessons can be directly applied from the Syrian context to this now new acute Ukrainian context. So our plan is to have some opening remarks from each of the panelists, and then I'm going to pose some questions to them that they can each address at their discretion, and then we'll open it up to conversation, and then I'll do a quick little summation, and then we can all go and have dinner. So we have a terrific panel today. I guess we'll go in this order since we're sitting in this order, if that's okay. We sort of planned it differently, but that's okay. Andreas, as we know, you've heard from him already several times over the course of this gathering, but is really doing incredible work in Europe with the European Center for Civil and Human Rights, ECCHR, has been in the lead in terms of representing victims and working with some of the cases that we've been hearing about. Catherine, of course, has a long and illustrious career in international criminal justice at a number of different institutions and now is the head of the IIIM. We have Hadi, whose work has sat at the intersection of human rights and technology, very cutting edge, both with the Syrian archives, one of the first documentation centers to immediately form and begin working when the conflict broke in Syria, and now with Mnemonic, which is thinking very creatively about technology uses and being able to capture machine learning and other tech capabilities in order to advance justice. And then Jean, who I had met back at Rome way back in the day, has also had a long career in human rights with Fidesz, with Amnesty International. She's now also an academic, and she's doing a lot of work on the rights of victims of terrorism, including in some Syrian cases, mostly in France. And as was mentioned, she's doing a mapping of universal jurisdiction cases. So why don't we start in that order, and we'll do our introductory remarks, and then we'll go to some questions. Great. Andreas, the floor is yours.
Yeah, thank you very much, and also thank you very much to the organizers for inviting me here. And yeah, happy to speak a bit first from a strategic point of view, also how we approach the situation, because also then to see, what are the lessons learned and how to evaluate where we stand today, 10, 11 years after this wave of crimes are happening in Syria. And there's another part we integrated in our work, that's the victims-centered approach and what that really means in practice. I think I will then speak to in the discussion. So from a strategic perspective, basically, in 2011, we started to focus on the region at ECCHR, started to building networks, Egypt, Tunisia, Gulf states, but then also soon Syria. And already also in 2011, the German federal prosecutor started these so-called structural investigations into international crimes committed in Syria. So, and that was, yeah, I mean, 2011, the world looked quite differently, especially in Syria. So, in that point in time, I think it was a really early and great decision to already focus on Syria and start investigating. Yeah, again, pretty early on. It started also then already. I mean, we started in 2012 with advising and accompanying witnesses into the structural investigations, so those who came to Germany from 2012 on. And then with the shift 2016, 2017, with many more survivors, but also lawyers, civil society and so on from Syria in Europe, particularly in Sweden, in Germany, some other countries. We also focused basically our approach and also saw where we wanted to see the investigations by authorities going and how we could yeah, push in those directions basically, and so we had to focus on the most responsible perpetrators, high-level perpetrators, and then on crimes such as torture and different security prison branches and so on. So these were cases we built together with those Syrians that came to Berlin, to Germany, to Europe. And then we filed in total 5 criminal complaints in 2017 and 18 in Germany against different branches of the security apparatus, and one specific file on the Caesar file, so where we transmitted the pictures and photographs taken by Caesar, who was also in touch with us, to the German federal prosecutor, and we also then started to file cases in Norway, Sweden, and Austria. And FIDH did so in France. We were in touch with Trial International, also what's going on in Switzerland, of course. So basically, there was a lot of coordination, and we were seeing, you know, which war crimes unit could contribute to which parts. I mean, in parallel, also the Genocide Network started its work on Syria. So things came together, and we yeah, put in this focus, and an additional focus was on corporate crimes. So the Lafarge case in France from 2016 on was based on corporate crimes also committed in the Syrian context as another aspect of the focus at this time in the beginning. We made it also all public. We had accompanying events, huge interest, not only by the Syrian community, so there was really also a push towards accountability after the failures to submit the situation to the ICC, and a lot of support also in German society. So you could feel that the time was come to really do more here and move on and really investigate and also prosecute cases. And it led to the first arrest warrants against those high-level perpetrators from Germany, from France, some years later in 2018, 2019, which I think is almost one of the most important parts, because that's the direction to go after those highest responsible, build the cases from outside, the evidence is there, and try to get them through arrest warrants, and they are out there and they will not go away that easily. So that was the first part, and then the arrests started of perpetrator identified in European states. So among them also the 2 individuals that were then put on trial in Koblenz. And this investigation also started. And in that investigation, we again we contributed to that one. Then specifically, it's of course a change of perspectives, also coming from trying to trigger investigation or to put certain focuses on investigations with now in a personalized investigation against individual responsibles to support building that case and to see that also survivors can participate on that, and that this is going forward as well. Again, I come to the survivors' role in the next round, basically. Then in the trial, what we did, and that already started also a bit before, is to see also which crimes are actually investigated and prosecuted. And we saw some gaps here, so we had a focus from 2019 on also on conflict-related sexual violence, which we then tried to feed into ongoing investigations, as well as there were motions filed in the Koblenz trial to add those as crimes against humanity, and they were added in the end. And the other part was on enforced disappearances, which was also not, for example, charged in the Koblenz trial, although of course there are many cases of enforced disappearances in Syria, but our motion was not successful, and it has also to do partially, I would say, with the German Code of Crimes Against International Law and how enforced disappearances are criminalized there. So that's part of a package we just presented to lawmakers in Germany with some reform suggestions for the German Criminal Procedure Code and the Code of Crimes Against International Law to also strengthen those for future cases on sexualized violence cases, on enforced disappearances, and on victims' participation in those international or universal jurisdiction-based trials, basically. I mean, what we want to see is, of course, more arrest warrants against high-level perpetrators, because we still think that's the main purpose. Of course, those perpetrators happen to be in Europe, need to be prosecuted, but I think the overall vision for justice in Syria is still to go against the most responsibles, and there it's still a long way to go. I mean, we're on a good way. There were first successes, but there's still a very long way to go. What we also want to see is to, again, look into all actors into the conflict, also from a justice perspective. So there are cases against non-state actors. ISIS was mentioned, the Yazidi case complex, of course, and the Syrian regime. What's not so far really in a focus were cases against Russia, and also what Turkey is doing in the north, and also around the anti-IS coalition. So depending on which civil society from Syria you speak on survivors, the understanding of justice and accountability is a complete different one, because depending from which backgrounds they're coming, from which regions they are coming, they have, of course, quite different perspective where this is at the moment and which groups were kind of represented in the trials so far, and perspectives and which one are still kind of lacking. So we still want to see kind of a diversification of investigations and prosecutions, and that's something together with Syrian civil society we are continuing to discuss. What we started in 2016, from time to time there are larger meetings where we have 15, 20 groups from Syria joined, and where we discuss those, where we are, where we stand, where we want to go, and we also see that that also Syrian civil society made a huge progress, are taking on many cases themselves now, which is great. So to pursue that much longer, and you also see the quite diverse perspectives on where you have had some forms of justice and some first successes, but there are also still many gaps.
Thank you, Beth. I also would like to start by thanking Klaus, the Academy, of course, and the Genocide Network for gathering us during those few days and having the benefit of this really enriching conversation. So I hope our panel will add to it. What practical lessons can be drawn from the Syrian situation? Certainly a lot. I would like to maybe name a few of these lessons that we at the IIIM have learned as we embarked in implementing this challenging but also extremely inspiring mandate that was given to us by the General Assembly. And the first one that comes to mind is really that when one embarks on such a journey, one needs a North Star. And at the IIIM, really our North Star that guides the implementation of the mandate is our inclusive, victims and survivors-centered approach. That's really what we keep as, the main purpose, and that really helps deciding what to do in the implementation of the mandate. The second lesson we've learned is that by relying on the many entities that started documenting crimes, part of the Syrian situation from the outset, and here I'm thinking states, but international organizations, including UN ones, Commission Inquiry, OPCW, NGOs, including obviously important Syrian documenting NGOs, individuals, and many others. I'm forgetting a lot of them. In relying on their work, but also in combining the use of digital evidence and even open source information with more traditional investigative techniques, well, in fact, the absence of cooperation from the Syrian Arab Republic, and even to some extent the absence of access of the mechanism to the Syrian territory, well, didn't prevent not only the collection, preservation, and analysis of very valuable information and evidence of core international crimes committed in Syria, or the building of case file. And this was not a given, I must admit, when I took the lead of the mechanism. Third lesson for me really is that it required a genuine two-way engagement with Syrian civil society actors. I think it was Rina earlier in a question to the previous panel was raising the valid question of documenting NGOs' willingness or lack thereof of engaging with the mechanism in the early days. And I think that I have to be honest, there was this kind of unsatisfaction arising from the fact we were not the court that the Syrians wanted, but also this myth that maybe the mechanism's central repository was going to be a black hole where all the effort they had put was going to fall into, and we would rubber stamp it as IIIM, and now the other efforts were forgotten. I think building trust, reassuring the NGOs that we were as attached to chain of custody as the actors, judicial actors we were going to serve, and that we would in fact make very clear to the entities we support where the materials we collected come from. We will seek to, if there was no chain of custody applying before, to take provenance statements from these entities to be able to provide the relevant information to recipient jurisdiction, and also that we were interested not just in their evidence or their information, but also in hearing from them about the crucial aspect of the Syrian context that a number of my colleagues were not sufficiently familiar with to do a decent job in supporting accountability. So that was the starting point, but of course, it translated into negotiating a protocol of engagement with Syrian civil society actors that now I know some other entity turns to say, well, that would be interesting for us too. It's part of the lesson learned. Making the effort of regularly meeting to share information about the work we do, to listen, and to also, I will come back to it later, to maybe consult as well on certain aspects of our works and understand the views of the Syrian civil society actors. The fourth lesson, really, that we've learned is that it is in fact possible to support ongoing investigations, currently predominantly at the national level, while conducting preparatory work for future judicial avenues, hopefully at the international level. I mean, Andreas is totally right. We don't have a spectrum that currently meets the need. I mean, it's great what's ongoing, but there are many holes there too. And it's possible to do both at the same time. I think it's critical to do both at the same time. I really wouldn't want the International Criminal Court or another tribunal to be seized of the certain situation and say, well, you know, here is the central repository. That's all I can share with you, because we were too busy supporting the national jurisdiction. I think we have this challenge of trying to make the best of both prongs of the mandate, if you wish. But it requires a lot of flexibility. I mean, adjusting to the many jurisdictions we support means you don't come to them and say, here is the way you're going to have to follow if you want to receive support from us. That's not the way it works. The way is, what are your needs? How can we help best? And basically learn how to have that agility, flexibility. And that's not, I think I've been working long enough in the UN to confess that it's not necessarily the best quality of the UN. We were often seen as quite a complicated body to turn to when you want to seek support as accountability actors. Maybe I will flag as a fifth lesson learned the fact that even if our mandate is not necessarily very crystal clear on that, I've considered that it permits support to criminal but also non-criminal forms of justice, and there are certain conditions for that. And maybe finally, going back to this expression of hopes for more accountability for Syria that Andreas was flagging, I'd say, even if the accountability ecosystem for Syria is still very incomplete and faces many limitations, I think it's fair to say that it's active and effective. And as far as I'm concerned, in my role as head of the IIIM, I'll say, with our central repository of evidence that so many entities helped building, our structured investigation, I hope having a chance to speak a bit more about that, our modular, flexible approach to developing analytical work and case files, we are able to play an effective role as justice facilitator in that ecosystem. At least I hope this is the case. Thank you.
So thank you so much for the Academy and for the organizers also for the invitation. So I have been working with this project, the Syria Archive, for 8 years right now, since 2014. And we absolutely learned a lot from this process as well. So the Syria Archive is formally right now a project of an organization called Mnemonic. We created this organization as a non-profit in Berlin 2018. It's a global organization right now that promotes human rights and accountability through the preservation and verification of open source and closed source digital materials. We started with the Syria Archive in 2014, as you know. With the organization Mnemonic, we are hosting the Yemeni archive, Sudanese archive. We've been working on Belarus, and right now we are setting up the Ukrainian archive in collaboration with Ukrainian civil society actors. So most of the lessons learned that I'm going to share with you is really driven from the work, the practical work of what we are doing when it comes to documentation. And I think one of the most important ones is that country like Syria and since 2011 was very inaccessible. And it was really hard for investigators to access crime scenes. It was very restricted, it was very dangerous. From the beginning, we really depended to understand about what's happening in the conflict on digital information published by people. But later on, with the years, we saw that this digital information that is documenting international crimes and human rights violations is actually being used by state investigators, by human rights organizations, by international organizations, as direct or corroborative evidence in criminal proceedings, but at the same time for advocacy purposes and for transitional justice purposes, for historical purposes as well. So we learned that this type of evidence is actually really important, especially when Bashar Assad right now, he's in control again of most of the areas in Syria, apart from some parts of northwest and northeast. But most of the physical evidence is going to be destroyed. We've seen hospitals being destroyed to rubbles after it being attacked multiple times. I don't think investigators will see anything if they go to the crime scene right now. But we have this in videos, in hundreds of videos, multiple times, that we are actually able to prove that there was a hospital at some point that was attacked 20 times, we can prove the location of the hospital. We can prove the weapons that were used. In some instances, we are able to identify perpetrators. But of course, in a lot of cases, it is very difficult as well. So what we learned is archiving is very important. Archiving these materials as soon as possible as a priority in many different ways. One of them, it should be automatic, because right now we have 4 million records of Syria when it comes to Syria. And right now we're working on Ukraine, 600,000 records since February. There is no team that is going to be able to handle archiving these materials. It needs to be automated. There needs to be some kind of a technology helping people doing the work. Because also public funding is not going to support different organizations in funding and having the team in order to do so. I'm really sorry, I'm completely lost track of time, so let me know when I should stop. So this is what exactly we did. Over the last 7 years, we built a methodology since 2014, talking to everyone, talking to experts from the ICC, talking to UN investigators, to forensic experts, and asking what is the best way to archive these materials? How do we make sure that these materials can be admissible as evidence? Even if it's digital information, in a lot of cases, we are able to get into the raw material. If we have the copy of it, we can get back to the source. But if we don't have any kind of a mapping around who published what and when, what is the name of the source, who is the source, we are not able to get back to raw materials. And raw materials still exist. So we did that to preserve and process and verify materials as potential evidence. In 2018, Human Rights Center at Berkeley and OHCHR published a protocol on how to conduct open source investigations, including protocols on how to conduct, how to do preservations in a way that you can ensure standards of criminal proceedings. That also fed into our methodology, into how to do this work. But that's the methodology. We need a technical system in order to do so. Because it's great to have the theory, but how do we implement it? So this is also what we tried to do, learning from practice and learning from experts that published the protocol of dealing with digital evidence. We built a technical infrastructure that is an open source archiving software that will be able to archive digital evidence from hundreds of sources that researcher can point to, or from certain locations, or for certain keywords, and all that is going to be automatically preserved, ensuring that there are proof to ensure authenticity, to ensure that this evidence is going to be available and accessible in the future. So that absolutely includes the design of how backup system will make sure that that the materials are going to be available. So, but with that, we have a bigger challenge, because we preserved, for example, as the Syria Archive, of course, other organizations have done a lot of work too. But from our side, 4 million records so far when it comes to Syria. So the lesson learned on the challenge, and what we try to learn from this challenge, is how to be able to analyze these materials, to identify at least relevance and reliability. So then to be able to use it, to submit it in different situations. For example, we get requests of assistance, we get any kind of requests to share the materials, then we will be very happy able to do so. And for that, we absolutely needed to make sure that we can design a tagging system in order for us to identify relevancy and reliability, and we need to build a technical infrastructure in order to see these materials even if they are removed from online sources. So we developed a media analysis platform that helps us now to process large amount of data with regard to different contexts, starting from Syria at the beginning, and then this work is extended into Yemen, Sudan, Belarus, and right now Ukraine, which right now is absolutely in use for these situations. Should I continue, or should I stop?
Wrap up and then we'll come back to some of it.
Okay. So I think just on this idea, it's really important that analysis is not going to happen with small civil society organization teams, and these kind of methodologies and technical infrastructure that we are building, it needs to foster collaborations, and that absolutely is possible to happen. Right now it's happening in Ukraine, and we can speak a little bit more about this, but without collaboration and engaging with Syrian international organizations, we are not able to scale up on analysis and be able to ensure that this relevant materials is used in different purposes for different investigation bodies and institutions. Last thing is, this was practically known to us because we've worked on submitting a complaint related to the chemical use in Syria in collaboration with the Syrian Center for Media and Freedom of Expression and the Office of Society Justice Initiatives, civil rights defenders, in collaboration with expert lawyers like Jean. And this work won't happen without this kind of collaboration, because every organization brings something to the field. It's a different methodology. We created, for example, chain of command for the 4th Division. We did it in a way with digital evidence, where our colleagues did it through witness testimonies. And corroborating these two ways was very helpful. And this is what we learned, and this is what we want to make sure that we share also with our colleagues in other contexts. Thank you. Thank you.
Thank you. Thank you very much, and thank you for inviting me to this conference. I'm really glad to see a lot of faces that I hadn't seen for many years. As the last speaker of the last panel on a Saturday, I was thinking that I would try to speak about, not so much about litigation, but about advocacy and the interaction between legislative review or legislative reform, advocacy, and cases, and how they interrelate. And of course, this linked to Syria, and I'm not trying not to lose sight too much. But I wanted first to say, it's probably obvious to everyone, that where we stand now is the result of 25 years of advocacy. A lot from NGOs, not only from NGOs, but also from victims association and from like-minded states. And I think that the UJ advocacy has been running parallel to the ICC ratification campaign 1998, and that we can maybe draw some kind of two different phases to get to where we are now in 2022 and the lessons regarding Syria. The first period, 1998 to 2010, or with the establishment of the specialized unit, was a time, and I think there was a lot of reference today and yesterday about these kind of attempts to have those cases win in the 2000, when the place to be was not Germany, but it was Belgium back then, or it was Spain. And indeed, there were a lot of attempts to bring to life some of the issues that were remaining as in full impunity in many countries. And I wouldn't be so harsh on those cases, because I think they brought a lot of information and lessons for the current situation. I'm thinking about some of the cases that were brought in Belgium. Some of them were extremely strong and solid, but what they lacked was political willingness and political support. What they meant was that they got a lot of countries afraid that politics and diplomacy would get in the way of justice. And what has been very critical in the early 2000s was this trend, which I hope is not going to happen again, and on the contrary, and that's where I'm going to get with Syria, which was this trend to narrow down the universal jurisdiction legislation so as to not allow victims to have full access to justice. The Belgian law was revised, the Spanish law was revised in 2004, 5, up to 2009, all with a view to give more power to the prosecutor, more prosecutorial discretion, less access to victims. And why? And that's because precisely back then, the victims and the NGOs were 99% in the cases were backing those cases, which is probably not as true today, or not necessarily true today, given the proactivity of a lot of specialized units and prosecutors, and the situation is different. So what's the difference between the Syrian cases that are ongoing in France, in Germany, in the Netherlands, in Sweden, and some of the cases that were brought against Don and Rumsfeld in Germany, in Spain, in France, or the Algerian case of the Moine de Tibérine in France, or, and I could go on like that. Of course, I mean, we all know the main difference is that there's no political will to prosecute those cases for a number of reasons, which I don't need to go into. And I think that the Article 17 of the ICC statute applies to universal jurisdiction when looking at it from distance. You know, the capacity and willingness and capacity. There's a lot of capacity, but there was a lack of willingness at some point to look into some of those cases. Now, what's interesting I find here with the situation in Syria, unfortunately, Syria is in the situation that it is, that it had to go and seek for creative thinking. And I think today what we've seen is that there's been amazing brains behind this creative thinking and strategic litigation. And we have this articulation between universal jurisdiction, but also International Court of Justice cases, and also some attempts to bring some Article 15 communications to the ICC to just cross the line and use interpretive creative thinking. And that's very interesting. But what has been key in those Syrian cases is that there was support. There's been strong support from European states to share responsibility in the fight against impunity. And that's not true for all the situations, obviously. And that's not true for a number of situations. And I think here with my Amnesty International hat, I think it's very important for all of us also to realize that it's as important to advance justice in Syria as it is to show that there's neutral and impartial in the case selection of all victims of international crimes. And I think we'll talk about Ukraine later. And getting to Syria, why do I think that it's an opportunity in terms of advocacy and legislative reform? is because of a case that you probably have heard in France. In France, we have a universal jurisdiction mechanism, which is a bit chaotic because we have three different regimes. We have a regime for the ad hoc crimes, the ad hoc tribunal crimes for the former Yugoslavia and Rwanda. We have another regime for the conventions, for the torture convention and the enforced disappearance. These two regimes you only need the presence requirement. So the alleged perpetrator is on the territory, and that's enough for French jurisdictions. But in 2010, there was a law that was passed in France, which is the result of what I just explained, or in Spain and in Belgium. Back then, 2010 was countries and governments were quite afraid about politically motivated complaints. At least the government in France was very afraid, and the law was passed to bring a new regime, a third regime, which is a universal jurisdiction regime for war crimes, crimes against humanity, and genocide, with very exceptional procedural hurdles that make it almost impossible to bring UJ cases in France. And for 12 years, Amnesty International, FIDH, many organizations have done everything they could, at least, but with no success at all, to try to ask the different governments to waive those procedural hurdles. One is prosecutorial discretion. For war crimes, crimes against humanity, and genocide in France, you cannot file a civil party application directly, whereas you can for torture cases. The second one is that the presence requirement is extremely limited because you need the residual presence. So you need like kind of a, not permanent, but not only the simple presence. And the third is a dual incrimination principle, which provides that you subordinate the case to the appreciation that the country of the nationality of the alleged offer has a definition of war crime, crimes, or crimes against humanity. Now, this has been going on for 12 years, but there had been no case because there was no defense. And that's why today is the result of the past, of course, is that now we have cases, and that fortunately enough, we do have cases in France, Syrian cases. And we have cases also of people that are actually detained currently and that have a defense. And they raised this issue before the Supreme Court. And in November 2021, what became a famous Chabon case, which is not really, has to be famous, we realized an opportunity for advocacy. This case, and I'll wrap up, this case is about a Syrian alleged perpetrator who was arrested in France after an exclusion clause, because he was not given the asylum status. And his defense raised the fact that in Syria, there is no definition of crimes against humanity. What did the Supreme Court do? They said, there is no definition of crimes against humanity in Syria. France does not have jurisdiction. You are free. That happened exactly at the same moment when Koblenz was prosecuting and convicting Syrian perpetrators. This was referenced by the French authorities as a tsunami, a sledgehammer. Apparently, the President Macron was very worried. The general prosecutor was very surprised. And they said, we are watched by the whole world on these questions as well as by our European neighbors. And I think that's the main point. This battle of sharing responsibility of the fight against impunity between France and Germany. We were very worried as well, and Clémence Bectard is not here anymore, but that's also an FIDH and SCM case. But we realized that it's an advocacy opportunity because finally, apparently, this universal jurisdiction law is embodied into, it's concrete. And so we have hope that we are going to be able to change or to push for a revision of this law, thanks to a failure. But given that there's political support. So I just wanted to bring these two kind of different aspects between the early 2000s and today. When there is willingness, everything is possible, apparently. Let's hope.
Great. Well, thanks, everyone. So one question for the group, which is, what do we mean when we say taking a victim-centered approach? That's a term that we've been using for the last 2 days. We've heard it said. We've gotten some glimmers of what that means. Andreas, you talked about enabling survivor groups to plug into national prosecutorial systems. You took a very non-extractive approach to working with survivor and documentation organizations with your Lausanne process, which maybe you can talk about. And you both have done a lot of work with survivors as survivor organizations, but also enabling citizen journalists to have their collections be utilized within justice processes. But maybe you could each take a moment and talk a little bit about what it means to take a survivor-centered approach from a methodological perspective in a very kind of practical way.
Yeah, thank you. And of course, this would then also apply, for example, to the Ukraine situation now and to all situations, basically. And it depends, on the one hand, also on the strategic approach I talked about in the beginning, because organizations such as ECCHR, we can't support too many survivors or all survivors. It's just too many. So that's why we also cluster and see which cases we want to support, want to focus on, where we can make a difference, be it Syria, be it Ukraine, and so on. Because I think one important part is if you work survivor-centered, it's a long-term commitment. It's not a few days, it's not a week, it's also not a year. I mean, the first ones on Syria we met in 2012, and we are still in contact with them. But again, you can't do that with a super high number. And then I think first we meet with survivors. Individually, we try to understand their personal situation, their motivation, already security issues around there. So just to understand who's coming to us, who's in front of us, with whom are we engaging here. And I mean, ECCHR, we have many lawyers in the team, so it's NGO work, but many parts are then kind of taken on by the lawyers as lawyers and as witness or victims representatives to then act as lawyers in those cases, including then civil party representation later on. And I think we talked a lot about NGOs, so they're quite different ones. So I think that not every NGO certainly has so many lawyers in there and have these close connections to lawyers. And but above that, we also have a network of psychosocial support centers all over Germany and also in other countries, which is extremely important for survivors, but also for our own staff. And we have other lawyers with other specialities, like certainly asylum law, migrant lawyers, also in a large network, and then also other criminal defense lawyers, because when insider witnesses turn to us, we often don't even meet them, but we see that they get a good legal defense lawyer, so that their evidence they can contribute is also kind of secured and hopefully then contributed or fed into an investigation. So there's a big network we use, and the first thing is trying to see that a survivor comes in a stable position, and with stable position I mean psychologically stable, responding to potential traumas and other things, then stable from a asylum status or status in the country. It's less relevant now for Ukraine, it was much more relevant for Syria, maybe about their families even. So that's one part, because our experience is if people are in a stable situation and feel comfortable, it's for them also much easier to testify and to speak about what they experienced in the past. So it's strengthening the evidence basically in the very end, looking from a prosecution perspective on that one. And then like our lawyers accompany them also in interviews with the German federal police or in other interviews, because again they feel safe, they feel they have someone with them who they know already, and who on the other hand can deal with the federal criminal police or knows them. So it also strengthens the situation basically. The next one thing is then to keep them informed, because sometimes they give an interview and then for 3, 4, 5 years nothing happens, or 10 years, you never know. But we're still in touch. We inform them also as a group, but also individually, especially if they wish and have questions and come to us, but as a group also that they feel part of the group. So in Koblenz, there were 25 survivors directly involved as civil parties or witnesses. But the whole group we kind of in touch with, which are about 130, 150 people, they all feel part of this basically, even if they don't have a formal role in the procedures, but they see it also as their success basically contributing with their statements. Then, of course, if it's on trial phase, it's much more intense, again, to explain what's happening, to support, to, again, accompany and update them, so that they, again, feel really comfortable and supported and stabilized when they give their testimony in front of the judges, in front of the accused. That's very important. And one other part is manage a lot of media requests, because media always want to speak to survivors, and which I understand. But most of the times, of course, it's not possible, and we don't allow that. We advise survivors that they also don't talk to media without consulting us. I mean, of course, they're free to do whatever they want, but we tell them what the consequences would be, and also with postings of social media and other stuff, of course. So we also advise on that side, and if there are some who really want to speak to media, and where we think from a strategic advocacy perspective also makes sense, then we accompany them also in the interviews with trusted journalists, also to see that they speak about the general situations, the motivation, but not so much, of course, about the case details and all those things. And like that, our experience was quite positive, that many survivors are empowered through this process. There's a certain ownership of the trial, especially in the Koblenz trial. And now there are a lot of events afterwards where survivors reflect on the trial, and you really see that they have this ownership. And their closing statements, where also some of the survivors made statements, they are extremely strong and powerful. There are some published in the annual report, which you can find online, and we have the full statements of some of the survivors on our website. It's fascinating to read them, yeah, that's the whole package, I would say, how we understand the survivor-centered approach.
Thank you, Beth. Well, I remind you our primary goal is to facilitate inclusive justice for victims and survivors of co-international crimes committed in Syria. And the experience we have of past accountability processes has shown that this can be challenging, in fact, to ensure inclusive justice, but that these challenges can be overcome, particularly when entities adopt proactive and dedicated strategies. And there are clearly structural factors that make it difficult to access to certain groups, and which have in previous accountability processes result in having certain victims becoming invisible or certainly less visible than others. And this will clearly apply to women, girls, boys, male sexual violence victims, but also persons with diverse sexual orientation or gender identity. So one of the concrete aspect of our victim-centered approach is really to try avoiding evidentiary gaps in our central repository of information and evidence concerning these categories of victims and survivors that are less visible. And it's an important goal in itself, if you think of it. Approximately half of the population, the world's population, is women. I believe about 30% of the same population is consisting of children. So if you think of an accountability framework which in fact fails to effectively take account of the experiences of women, girls and boys, let alone other categories of marginalized victims and survivors, well, you are really unlikely to get to reach a meaningful accountability for them, for all. So we are obviously committed to hear about the experiences, but also the perspectives and priorities of a broad range of victims and survivors of the Syrian situation from a rights-based perspective. So not only when they decide to come forward as witnesses, but also as part of this implementation of our mandate, which seeks to identify how best we can support accountability for crimes in Syria. And this is a way for us to make sure that our work is grounded, first of all, in the specific context of the Syrian situation, which they know and can help us understand, but also that the work we do reflect their views, their needs, their perspective, and I would say a key methodology for developing this approach is not, rocket science. It's really an ongoing dialogue with victims and survivors, particularly through relevant victims and survivors association. It includes informing them of the work we do, and you heard me saying that about the documenting NGOs. These are different groups. Sometimes documenting NGOs have in their constituency victims and survivors, but they come from a different perspective. And here it's really important to have space for that kind of engagement, but also informing them, but maybe hearing from them about specific aspects of our work in areas in which we seek to prioritize our unethical work. It's interesting to do it in areas which make sense for them, which matter for them, as opposed to maybe things where they consider we shouldn't be spending our time on. We're going to decide how to prioritize, but we can do it with knowing what does matter for them. But Beth, you asked me concrete examples, so I think I should also speak about very briefly three thematic strategies that we develop, one on gender, one on children and youth, and also one which seeks to support broader justice objectives. The first one, really, in a nutshell, our strategy on gender, I would say, has an institutional component, making sure that the IIIM is a place where colleagues are sensitive to gender. We don't think we can be credible in the commitment I spoke about earlier if in-house we are not sensitive to that we recruit people who either are already having expertise in that area, or if not, can be trained and willing to be trained on that. It's also about what I would say, maybe phrase as integrating a gender approach, a gender analysis in the various core aspect of our work. And we don't, this is also a lesson learned from the past, we don't consider that bringing a couple of experts saying, okay, you're in charge of gender, right? Meaning the others shouldn't care about gender, right? Or same with the children, that's not our approach. We have, when I talk about an institutional framework, it's really maybe a little bit sometimes ad nauseum from the top. Michel, my deputy, and I are really hammering those values. But it's also from the bottom. We have working groups involving each of a focal point from every section of the mechanism, and they were involved in developing the strategy. So when it comes to implementing them concretely, inputting in your work plan how you are going to concretely integrate this gender perspective, it doesn't come from the moon, it comes from the team. They've been looking at it, assisted with it by experts, but also they commit to implement it. And this, when I'm saying every aspect of the core work, it's really, I mean it, it's from the collection, the preservation, the development of the technological tools that can help capturing that. It's developing the analytical work and case files, and of course up to the sharing with the national entity. So hopefully this gender approach can benefit the recipient jurisdiction without, in a way, them having to make too much effort with that, if they rely on and value the work we do. And of course, It's also understanding the role that gender structural factors are playing in driving violence and discrimination in Syria. So more on the substantive side, we pay particular attention to the harms suffered by those women and girls and persons with diverse sexual orientation or gender identities, as well as victims of sexual violence. It may sound very general as I explain it, but I can assure you that it has translated very concretely in our procedures, but also in the outcome documents that we have produced. Maybe the most obvious one would be the last brief that we've developed and shared with jurisdiction, which seeks to demonstrate the existence of a systematic attack by members of Daesh in Syria, against victims in Syria, and which really looks at the discriminatory grounds based on which these attacks are committed, with one important segment of it being on gender and another on children and youth, but many other discriminatory grounds too. I will, for the sake of time, not go into the detail of our dedicated approach for crime against and affecting children and youth, but just to mention, we see it as separate. Sometimes entities mix the two and think, okay, if you take care of the women, take care of the children, it's going to be fine. These are different issues. Of course, we are inspired by the work we've put into the gender strategy because it saved us a lot of time, but there are also very distinct aspects of the strategy dedicated to children and youth. And the last element of this strategies I wanted to bring up is how we can support broader justice objective. I will give you only one example of that, but there are many others. This example is how to support the search for missing person, which, as you may know, in the context of Syria, is really one of the most pressing demands that families have. And it's not just about finding about the death, it's also finding about the living and where they may be, what circumstances they are currently facing, etc. So here again, we learn from past lessons. We know how much, for instance, the archives of the OTP of the ICTY are still being used 25 years after they were constituted by entities like the RCRC, the ICMP, and remember that these archives were not constituted with that objective in mind, so they have to search it, they have to mine for the relevant information. And we thought, okay, why not taking the opposite approach? Why not understanding from those entities what type of information they need? And when our analysts review a record, and we have over 2 million records, so we don't do a systematic search in every record, but when we review a record, at the moment, they tag the relevant information, and we share with entities that we can share with. So you may have heard that there is a discussion about creating a hub or a mechanism for to support the search for missing person, and clearly this is something which we would want to support, because that would be a home for that information. Really, we don't want a situation where you have to wait 20 or 25 years to access that information. And depending, I would say, on whether this is really happening or not, the General Assembly has asked us to look into what further step we could take to support the search for missing, and we would then, if we have a home, as I said, for such material, we would then look into other aspects. I'm currently myself leading a working group in the mechanism of focal from the different sections to look into what concretely more we could do, and whether that would require resources or whether that would be possible under the existing one. Thank you.
Thank you.
So very quickly, from the perspective of our work, as you mentioned, Beth, survivors would be people who documented war crimes, so witnessed, or families of survivors who have access to those archives. And our main goal and main approach is to make sure that we support the creation and maintaining the narrative of of survivors, of people who documented crimes, or the families of survivors. Because the Syrian government is very proactive in creating their own narrative, supporting specific projects such as the center that is called the Document of the Country, where they are conducting interviews and building their archives about what happened in Syria in the last 11 years. So with this, it's really important that we make sure that we support survivors in countering that narrative and making sure that their voice is heard. And we do that in the following ways. First of all, by either preserving their materials, preserving the media that they have captured, or referring them, for example, to the IIIM to preserve their materials. In other ways, it's about also getting back the materials that they have published online in case it was removed by social media platforms. In a lot of cases, we talk to people that take these materials, and in a lot of cases they tell us, a lot of them in Europe, that these materials are, it's all my life. And they value their lives with what they have captured in the last 11 years, or the few years that they were in Syria. So for them, it means a lot that we get back their online presence and what they have documented in the last years in Syria. So when we do that, we see how much the Syrian community is engaged and how much they get still motivated that there might be at some point some kind of justice. Other ways is about hiding some materials from online and making sure that it's private, because it puts some people at risk, specifically if it's families of people that are missing or in prison. So we get a lot of requests to speak with social media platforms, for example, and mention and submit a privacy claim to take some of these materials offline and make sure that it's hidden. It's preserved, but it's still hidden. So if people are still in prison or missing, or if people are right now under governmental control areas, then they are not under risk of being arrested. Making sure that we help them build the counter-narrative through building their capacity to also contribute to investigations, especially youth people who have been documenting and who are motivated to verify their materials, to contribute into investigations, making sure also that they contribute into advocacy goals when we submit certain complaints in different European countries, and making sure that we also highlight their role, because their role is essential. Without the materials that we got from them, we have a weaker case, and we have and we miss on potential corroborative evidence that can be really relevant. So those are mainly my points.
Yeah. I've picked on 4 lessons that are not specifically Syrian lessons, but I think applies, and that I'm trying also to apply on everyday basis. One is effectiveness of the right to information through managing expectations, and that's I think that's key to explain how judicial process is long, complex, and explaining that as much as possible very early in the process to protect them. Second is try as much as possible to provide effective access to the proceedings and the investigations as early as possible, at the pre-trial stage if possible. Because that helps them to get empowered, and also might very often help to shape the case accordingly and in relation to their to the stories and their prejudice and the crimes that have been that they were victims of, and it has helped very much. I have a number of examples where participation of victims, in particular in civil law countries where it's possible, as civil parties very, very early on in the case, has really shaped the investigation, where victims are able to, by bringing new evidence, to request through their lawyers supplementary submission, add charges, highlight issues such as sexual violence, which still today, often is or issues and crimes that are being overlooked. So and that comes very often through the possibility of victims to participate at the pretrial stage effectively. Very, very concrete, because Beth, you said very concretely, we were talking about that with Andreas. Translation is helping a victim-centered approach and empowerness when trials are being translated in the language of the victims, and when the proceedings, when possible, are being broadcasted one way or another. I have very bad examples of that in France, where victims of the November 2015 terrorist attacks, were the historical trial, longest in the history, there's no translation, and there are more than 100 victims, cross-border victims, 25 nationalities. There is no translation. There is no web radio that is accessible outside of France. What does it mean for victims if they are not able to follow the trial, these kind of trial? Yeah.
So, penultimate question, maybe if you could all speak a little bit about the way in which you've integrated modern technological methodologies into your approaches, thinking about things like preservation, authentication, even analysis, thinking about what role machine learning might play, and where you see the field potentially moving in the future, where there are gaps, where tech could fill those gaps. I used to live in Silicon Valley, and they assume there that technology can solve every human problem. I think that's probably not true, but they can solve some problems. And I think some of the problems we've seen in this new digital landscape of the issue is not so much you don't have information, it's that there's too much information, and you have to think about how to deduplicate that information, authenticate that information, deal with mis and disinformation. And so it's almost the opposite problem that we used to have in the old days. So I'll let you each maybe take a crack at that question.
Yeah, thank you very much. And I want to be short. On the one hand, like if rewriting criminal complaints, of course, we use an open source information to integrate it there to give certain leads for further investigations and stuff like that. So there certainly it plays a role, and then also what other organizations doing to feed that into specific research, open source in certain command structures or stuff like that, or locations. But maybe can I also direct your question into that direction, that also the courts should use modern technologies to record those trials. It's something we also had on the first day already here in the discussions, the audio-visual recording of trials, and the debate whether that could influence or negatively impact witness testimonies, where I think we are on agreement where witness protection is needed, it shouldn't be recorded. But there are witnesses that speak up also in the media and elsewhere, and that could be recorded, expert witnesses, and of course also closing arguments and statements and stuff like that. So that also courts use in Germany specifically more modern technology, and it's not the tech you are talking about in Silicon Valley, it's basically recordings of those things and handing over. We had it also reported from his observation in Celle. We know it from many Syrians who came to Koblenz who couldn't follow the trial because it was all in German. It was translated for the accused and the civil parties, but not for the public gallery. And that's, I think that's extremely bad because it counters the purpose of universal jurisdiction cases, why Germany does those cases on behalf of the international community if it's not really accessible to those communities. I have only very little demands with modern technology starting there, but of course with tech in terms of investigations and building cases is of course much more to do, but I'm pretty sure Hadi and others can say much more about that.
Yes, thank you. As I said, our central repository currently aggregates over 2 million records, and the crime base, the linkage evidence, the information that it contains includes victim and survivor testimony, documents and witnesses from inside structures of interest, flight data records, intercepted communication, evidence from overview and expert witnesses, material from very different sources, UN actors, which are not always very easy to access to by other entities. The formats are very different. The evidence also is in the form of open source material obtained from the internet. So, I mean, clearly managing effectively the information in this repository is of key importance. And for this, we rely at the IIIM on a team of information management professionals with a specialization in digital work that is necessary to support investigation, but also analysis. And getting the three working together was initially part of the challenge. It was not so obvious. We had very experienced investigator analysts, but used to more traditional forms of investigation and analysis. So really it took a lot of time to get them to work together. But in terms of the technological tools, we obviously channel the collections that we make in support of our lines of inquiry into what we call evidence pipeline. And the technology helps, for instance, to remove irrelevant materials or to make relevant material easier to find. For instance, we are using technology to identify duplicates and near duplicate material. When it comes to video material, it's critical. If you have hundreds of videos potentially containing very graphic material, and you have your analyst going through every single one, that's not going to be efficient or even possible at all. So we're also using multi-language optical character recognition to improve the searchability of the materials. And obviously for some type of digital material, particularly multi-format data obtained from the internet, a traditional document search and a review platform was not sufficient. We started with that at the IIIM, but we quickly realized that we had to increase our capacity. So to meet that particular challenge, we have developed in our structural investigation what we call a multimedia evidence review platform using technology, but of course also human beings. And that helps us to find, to review, to mark up evidence contained in the central repository, whatever the format is. And I'm sure that Hadi can speak even more eloquently to the technical details that I can. But basically, these tools are really helping to process the material, and when that is done, then the data that have been extracted are available, extracted or copied. We of course keep golden copies of the original materials. Then this material is made available for analysis, and we of course, I should have mentioned that we of course retain every search that has been made, material that has been tagged, so that if another analyst, another lawyer goes through the material, this person will be able to see who has seen it before, why, and for what specific purpose, line of inquiry, or search for the missing, or any other gender, for instance, specific. The material was reviewed, and that in a way creates an ever-evolving knowledge base of all the evidentiary inquiries that we are running in the central repository. Thank you.
So from our side, we learned the lessons on how to use technology to support three main things. Two things: it's preservation and analysis. And there has been a lot that has been done on preserving evidence, and there has been many tools, there has been many kind of applications. But the challenge is how to scale up this kind of preservation from doing it for each video individually, or from scaling up into doing it for hundreds of them. So what we have learned is it's really important to make sure that when it comes to preservation, specifically when it comes to the open source content, is to make sure that this process is automated as much as possible. So daily we're able to preserve materials from specific sources, from different sites, from specific locations, and from specific keywords that we get from the search results. And most importantly, how this information is going to be processed, because if it's going also to be processed individually, it's going to be a huge work. But if there's a pipeline that can automate the process, specifically when it comes to ensuring authenticity of the materials, then this will be really helpful to scale up the process of preservation. So making sure that screenshots are done automatically, hashing and timestamping for every piece of media that is preserved, as well as taking an HTML capture also of every media that is preserved. So the minimum that we need to ensure to meet the legal standards. But as you have mentioned, with this we accumulate lots of materials from open sources and also from closed sources. And then the issue becomes how to ensure that we, in the end, create an archive of relevant and reliable material. So the analysis becomes really the big challenge here. And what we've learned, it's really important to make sure that we build a media analysis system focusing only on media, focusing mainly on open source content and closed source content, in order to ensure that analysts are able to collaborate on verifying and tagging this media, and making sure that this media is able to be exported into any case management system, into any legal case management system that other institutions or other international collaborators or senior collaborators are using. When it comes to analysis, the main work until now, it's manual. We are not able to really automate this process. How much we use machine learning, there will be lots of false positives and lots of mistakes. So the work is still very much manual, so we need to make sure that this infrastructure is allowing collaboration to scale up. But when it comes to machine learning, we have we have worked since 2017 on machine learning software to detect certain objects within a video. So then a certain type of ammunition will pop up for researchers in order for them to do the verification on it, but at least it's some kind of prioritization. The second thing is when it comes to deduplication. So the CIA Archive was part of project with Benetech and SJAC and other partners in order to test the tools when it comes to deduplication, making sure that we don't have an over documentation or duplicated materials. And then the third thing, which is also really important, is using machine learning to protect the work of the analysts. So as much as possible, they won't be able to see graphic materials if not needed to. So then machine learning will help us on blurring certain images, graphic images or violent images, specifically if the researchers are not ready, or it will give them the time to be ready to conduct this kind of analysis. So these are the main two things that we've learned and built throughout.
I don't have much to add because I'm not an expert in the use of technology. I can just testify to the extraordinary importance of user-generated content when analyzed by organizations like Syrian Archive, and with a lot of rigor and a clear chain of custody to the extent that it can be filed. as leads to investigators and judicial process, and I think it's quite extraordinary in terms of the analysis of crime base. It just speeds up a lot this analysis. Of course, it's not so helpful for structural, the analysis of structure, maybe, but for crime base, I find it in the last couple of years really quite extraordinary development.
Great, so before we turn to questions, maybe if everyone could just give one piece of advice to teams that are now trying to conceptualize what accountability and justice are going to look like in the Syrian context, maybe from your experience of working, in the Ukrainian context, from your experience working with the Syrian context, and then if folks want to think about questions, we'll turn to questions just after.
Yeah, thank you. So I think it's, a lot of issues have been raised the last days, so I think something particularly is extremely relevant, which I assume prosecution services do as well, the OTP does, but also NGOs should do, is to see, which set of cases should be best prosecuted where, and which perspectives are kind of represented in those cases. So it's kind of like a matrix where you see, what are the perpetrators to go after and what are the strongest cases to go against them, and where you can be prosecuted best, and which kind of crimes should be prosecuted, more from that perspective, and what's the best place. And within that also, as Catherine mentioned, how are women affected, the cultural scene, LGBTQI, children, elderly who cannot flee certain areas. So I think there are a lot of then other aspects in there on the, what kind of crimes are committed and what's the impact of the crime on certain parts of societies or groups. And then to see in this kind of matrix what kind of case should be pursued by whom, where's the evidence basically also on a particular case, and who's doing what. And I think that's, of course, it's nothing that you do on day one of a conflict, of an invasion, but it's now starting, I think, where the time comes for all, for prosecutors as well as for civil society, to see where to go and strategically and how to build cases and what do they mean for whom and where to prosecute them.
Maybe a lesson I think could be or an approach rather that could be transposable, particularly in the context of Ukraine, is this notion of a structural investigation. We heard national prosecutors speaking about their version of it, which really inspired us. I think in our understanding of what the IIIM can do to add to that, it's not just a way of centralizing the information that is relevant, it's also a way of identifying the key questions that need to be answered in order to prove, to charge and to prove co-international crimes. So, looking at the entities behind the crimes, the individuals within the crimes and the role they played, looking at the overarching contextual factors that can be elements of crimes, like existence of an international armed conflict and the nature of it. Not too difficult to imagine in the context of Ukraine, but still you need to prove it, and identifying the relevant evidence, the existence of widespread or systematic attack to prove and to charge crime against humanity, but also the other contextual aspects that are really important to situate properly the crimes in the context. Maybe as well, at least that's what we are doing, trying to identify the patterns in the purposes that underlie the crime. And that can be really captured. The analytical work surrounding those issues can be captured. So if I was to think of a structural investigation in the context of Ukraine, I would say, since you have many entities, we talked about coordination earlier several times, since you have many entities, really the importance is to re-inject in the structural investigation, the analytical work that is done by the different entities. And that's what we try to do in the context of Syria, and use the cooperation frameworks we have with national jurisdiction to be able to seek to obtain the underlying evidence they've been relying on, translate the judgments into Arabic or into English when it's in a different language, and of course re-inject the analytical work that they've done that can answer those questions. I think that's really an important aspect of the approach. The flexibility I was talking about, the modular approach, can be also of use in a situation like that, because if you are supporting more than one prosecutor team and more than one national, international court, maybe you need to think about what can be detached from that work that you do for one that could be of use to another. That's really functioning very well in the context of Syria, I find, so far. Well, I will stop there for the sake of time, but just to mention that my deputy Michel, during the last Genocide Network, actually gave a very detailed presentation of how that it works, the structural investigation at the ICTY, including with visuals, which I think are really useful, and that, of course, is with the Genocide Network, and I hope can be made of use by the teams working on Ukraine. Thank you.
I think one of the lessons learned that we're actually also right now as Syrians, we are learning from the situation in Ukraine. So avoiding over-documentation through collaboration. This is really important, especially it's really important to make sure that there is some kind of a general thinking for civil society organizations that public funding will shrink eventually, and it's really important to build workflows and methods based on collaborations to sustain the work that they are doing on the long run. The second thing is when it comes to priority is when it comes to preservation. This is what we really didn't start in Syria when it comes to the open source content, at least, and of course the closed source content. But we lost many pro-governmental sources, for example, in Syria, that they were removed. Their online presence was completely removed. So this is really important when it comes to perpetrator content online as a priority for preservation. With Mnemonic, we've set up the Ukrainian archive in collaboration with a coalition of Ukrainian organizations called the IIIM Coalition. So we see the collaboration is starting to happen from the beginning. And we preserved about 600,000 records so far since February, but that really tells us also about the large amount of data that is being captured. So collaboration on analysis and verification becomes really a priority to make sure that they are able to sift through the materials to identify relevancy and reliability. And making sure that these materials and collaboration, I think it's really easy to happen and possible, and we really our recommendation to encourage it, especially with the open source content, because it's public anyway, and that makes it easy for different organizations to collaborate together. With closed source content, it's really understandable that, for example, it's confidential. Every organization will deal with it like separately. And lastly, it's the importance of sharing with accountability institutions and sharing with prosecution authorities and getting feedback and making sure that the work is improved when it comes to analysis, when it comes to verification. This is really important. This is what we are learning from sharing with the IIIM, from sharing with prosecution authorities in different European countries. We are building our skills, and I think this is the way to keep the work sustainable regardless of funding, because in the end it will shrink, as the case of Syria right now.
First, I think we would all agree that it's quite it's very interesting to see the interactions that is going on today between Syrian human rights defenders and Ukraine. I mean, this exchange of information, this exchange of knowledge, this willingness to help, to support, to bring lessons, I think it's really fantastic. So I think hope, not that it's perfect at all, but there are currently, I don't know how many investigations going on around the world in relation to Syria. I don't know how many, do we have numbers, but quite a number of them are happening. What?
Yeah, hundreds, but it's not, I mean, the exact figures that...
No, okay. So, but there is hope, and I think that's what's needed right now for Ukrainians to look forward. Just like maybe there was a lot of hope in 1998 when Pinochet was arrested. I was going to say there's no proper good presentation without quoting a little story we've read, if you don't mind. No, because I was thinking about hope, and I was remembering that Reed was at the Padichayo to celebrate the 50th anniversary of the Universal Declaration of Human Rights, and I was an intern at FIDH, and he was up the stairs, and he announced to the NGO representative and human rights defenders that were there that Pinochet got arrested. And I remember the hope that I remember the reaction of the Algerian woman, of everyone that was there, and I think that's very important. This exchange of that it's possible again.
Let's open it up to questions. Sarah?
I actually have a comment and a question, if that's possible. First of all, I'm really inspired by the last point that was talked about on lessons learned. I would just like to point out for something that's really important regarding activists who are in the conflict zone. 11 years ago, when the Syrian revolution started, everyone started documenting through shooting videos and pictures. And these empirical evidence are really important. But now, in 2022, this kind of culture has spread more and more, where we have manuals and we have guidelines on how to take videos and film protests demonstrating against their authorities. And I think it's really important to educate and spread awareness for those who are still inside the conflict zone on how to collect this evidence, not only to preserve the chain of custody, but also to maintain the metadata that we need when we collect open source evidence. That's the comment. Regarding my question, I would like to ask about some of the ways that several authoritarian regimes follow, especially when the conflict is prolonged. They produce every now and then, I don't know, decrees, regulations that show that they are enhancing human rights situation in the country, but in reality that's not working. And as an example of that, I would like to speak about, sorry, excuse me. I would like to speak about the recent anti-torture law that the Syrian regime issued. It was, I think, a month or 2 months ago, and I would like to know, like, how would that affect the accountability for the past crimes, and how would it be applied? It would, like, crimes that happened in the past be disregarded because of that law that was proposed? And also, I would like to speak about the recent amnesty decree that was issued, in which around 200 detainees now are released, who were detained because of offenses related to terrorism, but not offenses related to political characters, which leaves more than 132,000 forcibly disappeared persons in Syria without any fate revealing. My question is, how is that seen in the eyes of the international community, especially with the support of several allies such as Russia with the Syrian regime? Thank you.
Anyone?
Maybe answering to the first question, I don't see you anymore. Yeah. Sorry. Maybe answering to an element of answer. It's not necessarily a perfect answer, but I would say very likely this kind of element, like a law prohibiting torture, is likely this kind of element will be brought up in cases about torture. It's natural. If it's not by the prosecution, as part of a case, it's going to be brought up by defense. Now we have examples. I'm thinking particularly of the former Yugoslavia, but also in the Khmer Rouge trials of this type of evidence, which was introduced to show that, well, you can see there was no torture because look. And I mean, the judges take that into account and have to make up their mind as to whether this is genuine, to whether it's a cover-up, or to whether it's, an attempt to limit certain crimes at some stage, but that was not followed by any action to implement. So I wouldn't be overly concerned. It's natural that this kind of pieces of documentation find their way in a trial, in a case. And then I trust that as part of the overall assessment, the judges know what to rely on and how to rely on this kind of material. It's more complicated to answer your second question, I think, because it's a very broad question. On the one hand, of course, you want to, you're happy for those individuals that are released, because I think that also brings some news, good news to their family that they were still alive. Even I understand not all of them are in a very good shape, but at the same time, it's very difficult to read what it means exactly.
Trust anything to add?
Yeah, maybe shortly. I mean, if the intention is that Assad will, through those steps, being more recognized in the region as a state leader or something like that, to return back to the diplomatic field and scene, I think that then needs to be really strongly rebutted. And I hope I hope not that this is the strategy and would even have some success. I mean, he started traveling again, and I think there's a danger that for whatever reason things change and he's more accepted, and I think that needs to be strongly rebutted, and I think that's what I want to say on this point.
Yeah, Bill.
Thank you. This is really interesting for me. I hadn't actually read the schedule before I got here, so I didn't know there was a session on Syria. So it's a real delight. But so the question from the issue then is, where are we going now? 11 years into the war, a lot of money's been spent, a lot of expertise has been developed, most especially, and I'm not speaking about tactics, but operations. So let me frame it a bit, if you'll permit me. So we had the Koblenz trial. We've got 2 convictions of security intelligence officers for crimes against humanity. One, Ruslan got a life sentence, something like that, if I recall. Yeah. So from a justice perspective, from a victim-centric justice perspective, this is a very good outcome. Why did things go so well? Well, first and foremost, because the German authorities, the federal police, and the federal prosecutor's office had the moral courage to take the case forward, because there's always a risk that you lose. And I would suggest, though, that what we saw overall, and this is from my perspective in terms of looking forward, but please disagree if you think otherwise, what we have is a perfect model of public-private cooperation to justice ends. It wouldn't have worked as well, and possibly not at all, without the contribution, for example, of ECCHR. I know you're involved in many other cases, Hadi. I don't know if you were involved in this. You were in this one. Mazen's outfit in Paris. Mazen testified as an expert witness. CIJA did its bit, as so forth. And all the pieces under expert German management, if you will, of the prosecutor's office came together perfectly. Now, you've spoken today, three colleagues here are from the human rights community, if you will, NGOs. I'm an NGO guy, so there we are. Sometimes I forget. But you spoke to some degree about, let's call it litigation to strategic ends. Yeah, so getting arrest warrants for, I don't know, this case in Spain and making criminal complaints and so forth. It's a form of advocacy. CJ doesn't do it. It's not part of our mission, although we do support these efforts. If someone asks, they need documents and stuff, we will do it. And I'd like your thoughts on whether you think it's really worthwhile to continue to put resources into that advocacy through litigation in the Syrian context, or maybe try to shift even more towards litigation where we will get a prosecutorial initiative with ultimately a conviction. I don't have a view on what it should be, to be quite honest, but because just I don't know to what extent people know, but CJ, well, everyone knows CJ receives requests for assistance from many countries and so forth, as indeed does IIIM. CJ's received since 16, so over the last 6 years, almost 800 requests for assistance, formal requests for assistance, concerning about 2,500 suspects. I would say about 60 or 65% of those suspects are Syrian regime figures or suspected Syrian regime actors who are present in the West. Yeah? No, most it's the public authorities just doing their job and check whatever. Occasionally it's immigration inquiry, very occasionally. But with that kind of volume, there's a tremendous potential, if with better resourcing, to see more criminal prosecutions. So, thank you.
Yeah, I think it's a good point. I mean, of course, we also observe what's going on, who's doing what, as far as we can, because, I mean, of course, we don't have access to all information. Also, as far as we can, what IIIM is doing and so on. And of course, like that you see strategically, are there blind spots? And then, if we think they should be addressed, we would again push for them through, again, advocacy, criminal complaint filings to fill them, but we also see a lot on those investigations, cases and so on that are going on. Which context do they concern, which crimes are prosecuted in those, and would it make sense, and do we have information where we think, okay, there should be more charges filed in that one. I mean, I know that prosecutors try to do a really kind of effective economic kind of cases and not overburden them with charges, and I fully understand that. Like in the Koblenz trial, you could also see after the first weeks and months how this goes, whether you can add charges or try to add charges, or whether that would also overburden the process, things like that. And especially like on conflict-related sexual violence, we did it in certain cases because it wasn't that much represented, and we tried to get it also in that case in ongoing investigations. So we will relate, and I think same with a number of Syrian organizations with whom we discuss those things. We will engage with what's going on anyway, I would say. And then if there are blind spots, I think there's also a way to expose them or to address them. So I think these are yeah, these are exactly points we're still looking into in the Syrian context, but again also in many other situations, of course.
Well, I don't think in the Syrian situation we have the luxury of dismissing any, viable justice opportunity, and our figures are not as impressive as yours, Bill, but since we were created, we received 190 requests for assistance from 14 jurisdictions concerning 156 distinct investigation. Of course, some investigation more complex lead to more than one request for assistance. And we've been able to support 101 of them. So that's the record that we have so far, and it means searching for for material, providing identical product with done, connecting witnesses with prosecutors at their request, or interviewing witnesses in other instances, geolocating crime scenes, etc. But what I want to say with this is, before the Ukraine crisis, I would have predicted with no hesitation that the number was only going to grow, right? I must confess that my concern is, I'm sure the ongoing investigation will be pursued. My concern is, are the prosecutors going to have to now make a choice and say, this is impressive, the amount of work that has been done. You of course referred to landmark judgments, but over 35 or even 40 verdicts since the beginning of since 2016, if I'm not mistaken, in only 4 countries, right? Germany, Sweden, Netherlands, Hungary was one case. And that, of course, we could say, well, great, right? Well, the reality is it's a drop in the ocean when you look at the amount of crimes. And of course, mostly non-high level perpetrators. So I would be an advocate, I'm not, of human rights. I would go for making sure that the resources are maintained to allow the prosecutors to continue investigating these crimes at the national level, because we know it works, and we know from what you said that probably a number of perpetrators still present on their soil. I wouldn't give up on advocating for other forms of accountability, and I'll tell you why. I'm not privy to what really triggered the decision by the Netherlands and Canada to undertake the process invoking the violation of the Torture Convention by the Syrian regime. But I mean, this is a type of addition to the accountability spectrum that really can make sense for the victims and survivors, I believe. So, no access to the ACC now. Well, although we know that submissions are made to the ACC to, use creatively the decision in Myanmar that could be concerning the Rohingya, that could maybe do an opening. I wouldn't give up on any of that, right? As long as you don't have a record where you can tell the victims and survivors, okay, we will never have all the crimes and all the perpetrators charged. Let's not be misleading there. But we have a sufficiently representative spectrum of crimes that have been, effectively brought to justice, and we have a sufficient range of perpetrators. And we know national prosecutors will have some limit there, although there are international arrest warrants concerning Syrian senior Syrian suspects. So that's my piece of advice.
So very quickly from my side, we invested a lot in the last 11 years. International organizations such as yours, Syrian organizations, accountability mechanisms. It's 11 years of skills and learning and experience. And we are at the point right now where, when the invasion happened in Ukraine, we started working directly. We directly were implementing, we directly were preserving, we directly were verifying. Analysis is happening on a daily basis. And I think it's really important to build on this. It's really important to make sure that we are able to sustain this resource and continue on building this resource. Now, the issue that we have when it comes to Syria is the lack of accountability avenues. As you already know, thanks to Germany and the trial that happened, this was really helpful, and it gives us a lot of hope when it comes to the situation in Syria. And I really hope for other countries to also conduct investigations like what Germany and France and Sweden are happening. This will be really important for us. And it's really important for us also to make sure that these investigations cover other type of international crimes that we have lots of documentation on, such as attacks on medical facilities, the use of illegal weapons. These are the same techniques that are using by the Russians right now in Ukraine, because no one said anything to them in Syria. What we really also hope for is more joint investigative teams between different European countries, because this will be really helpful to share resources and make sure that these resources also make sure that what we've learned in the last 11 years are contributing to those resources through JIT's teams. So this is my take on this.
Last word, Sean?
Yes, just to say that I think also that it's important to continue to be strategic enough so that the current cases, as you were describing, those that are the underground cases that will hopefully at some point become, real investigations and maybe trial happen, but also because there are upcoming issues such as immunities that will, there are further obstacles that are coming up in some of the investigations, Syrian investigations, and even I'm thinking about investigations in France or in Germany right now, where this might happen, where there are no defense yet. And the other thing that I was thinking is that it's important also to keep the balance between a tendency to go for terrorism-related charges versus international crimes, and this whole discussion about cumulative charges or specialized unit be under terrorism units in terms of resources, etc. I think it's really important to continue to really struggle for the right qualifications, the right legal characterization to reflect the reality of what the victims have suffered.
Well, please join me in thanking this terrific panel.